Hello, this is Matt on the Moon Lambo channel, and I have another hot jam for you today that will not disappoint. And it's a legal update. You're going to absolutely love this stuff. We got so much to talk about in here. Do you remember this headline from a week ago? It's what's on your screen right here. This headline happens to be from Finance Feeds, but all of crypto media was talking about it. And this one's titled, Ripple Buries SEC in Paperwork in XRP Lawsuit. Nearly 30,000 requests. And so this is where Ripple was requesting about 30,000 requests of admission. And this is something that's common within the legal industry, if you will. Not that 30,000 is a particularly normal number, but it's not like it's never happened before. These requests for admissions, it could be something rather simple, just to make something up. Say there was a car accident, and one side of the case says requesting requesting an admission from the plaintiff that the car in the accident was blue. You know, it could be something very simple. It's not that each of these requests that the SEC would have to answer would be truly burdensome necessary, and that's the claim they're making, is that there's like way too much time to answer all this stuff. But some of these are very quick, where you don't have to do an analysis. It's a yes or no. It's very obvious, very apparent on the surface. And so the SEC is claiming that this 30,000 number, because that's how many requests Ripple refiled, that it was just burdensome. There's no way we could do this. Ripple fired back. But there's even more interesting stuff than that. We found out in this most recent legal filing from Ripple that a law firm told a cryptocurrency exchange to list XRP. Now, we already knew that in 2018. A cryptocurrency exchange met with the SEC and then after that filed. But now we're learning that that there was a law firm that told them to. Now, that's kind of stunning. So where's this legal clarity that the SEC is claiming exists? Clearly it doesn't. This is huge for Ripple's case and their fair notice defense. And then also, and I love this, this might be my favorite part of the whole thing, just because it's comical to me. The SEC, I'm sorry, or Ripple rather, like they're playing like, I don't know, what do you want to call it? Like 4D chess? Like, what is this? They tricked the SEC into admitting that they didn't analyze evidence that they would have to have analyzed to have made a crucial claim that they made against Ripple. It's astonishing. I tell you, these asshats at the SEC, they do not have it together. But I want to be clear at the outset, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby, just for fun. There is nothing special about me. Other than my awesome name, which is Moon Lambo, and it's awesome because it's the stupidest name in the entire XRP community, and I'm proud of that. Shout out to James Filan, who shared this most recent legal filing that Ripple put out with the XRP community on Twitter. I'll tell you, he's my go-to source for finding the latest stuff. He is just absolutely on it. And here's the legal filing in question. So what I did is, hear that? I printed up this bitch. We got 6 pages worth of dead trees up in here that the SEC made me slaughter. And I highlighted the most interesting parts of this, and I actually did take some notes because I didn't want to forget my thoughts on this. So let's go ahead and just dig right in. And so here you go. Dear Judge Netburn, we write in opposition to the SEC's request for a protective order permitting it to avoid responding to defendants' 4th, 5th, and 6th sets of requests for admissions, RFAs for short. The RFAs concern critical facts that defendants believe are not genuinely disputed. Truthful admissions by the SEC will therefore significantly narrow the issues for trial. Now, the SEC does not seriously argue that the RFAs are relevant. This is what Ripple attorneys write. Instead, it focuses almost exclusively on the sheer number of RFAs to argue that they are, quote, unduly burdensome, end quote. This is simply wrong. First, as a matter of law, the large number of requests to admit is not in itself a basis for a protective order. And then second, as a matter of fact, the defendant's instructions will likely require the SEC to respond to only a fraction of these RFAs as described in greater detail below. And so that part was kind of a surprise, the idea that the SEC actually won't have to respond to all 30,000 requests is a virtual certainty. And that I was kind of wondering. I'll get to more of the reasons why towards the later part of the video, because it happens to be at the end of this this legal filing here. But check this out. I love this. This is the part that happens to be my personal favorite out of everything in this document. Check this out. So Ripple's attorneys write the following. Third, the quantity of RFAs is proportional to the needs of the case. In fact, it is driven by the SEC's own litigation theories. The largest set 6, is based on the SEC's contention that every offer, sale, and distribution of XRP by defendants during the relevant period of 2013 through December 2020 was the offer, sale, or distribution of an investment contract. So just pause right there. It's a very simple claim. We're all aware of this. The SEC is claiming that all of the XRP that Ripple sold for that roughly 7-year period, all of those were securities. Those are investment contracts. That's what they're claiming right now, right? Which is why this next part is so highly relevant. Check this out. That contention puts centrally at issue the express terms of more than 1,700 separate contracts. So pause. We're talking about 1,700 different sales or distributions of XRP, individual ones, right? Well, that's what the 1,700 number is that Ripple's attorneys just cited there. And then they write, yet the SEC now complains that it would be unduly burdensome to require the SEC to review the contracts it alleges are unlawful securities offerings. This is a remarkable admission. Apparently, the SEC failed to review these contracts before alleging it in its complaint that every single one of them was part of a course of unlawful conduct. Indeed, the SEC seeks disgorgement of at least $1.38 billion in revenue generated by Ripple from those exact same contracts. Yet it says it can't be bothered to actually read them. My God, you know what? That's a standing ovation, right? Everybody just stand up and clap, right? Can you believe this crap? Think about this. So look, consider this. Ripple filed... we learned this a week ago. I covered this thoroughly what happened. Those 30,000 RFAs, requests for admission. They filed that as a trap for the SEC. That's what I think. Knowing that they would complain, it's too much to analyze and answer. And in doing so, they admit that they didn't analyze every transaction that they're claiming is a securities transaction. How could they know that every single transaction is a securities transaction if they didn't review them? It's a study. This is a studied admission. This is some next level stuff right here. The SEC fell directly into this trap. Truly astonishing. So I hope you can see why this is my favorite part right here. As soon as I read this, I just started laughing out loud. I was LOLing as I was preparing for this latest Moon Lambo hot jam up in this bitch. It was a good time. I was like, oh, I can't wait to tell everybody about that. This is fantastic here. That's my favorite part out of this 6-page document here. But there's still something that's just about on par with that, and I would get, like, I don't have a legal background, but in terms of carrying weight, this next one, although it didn't make me laugh as much, perhaps it's just as pertinent as what I just covered with you. And so I go to page 2 now here. We're looking at fourth set. Yeah, here we go. Fourth set. Almost every RFA in this set addresses the SEC's own documents, its communications with third parties, or the authenticity of documents that may be introduced at trial. To take just one example, and it is rich. To take just one example, when one cryptocurrency exchange decided to list XRP, it obtained legal advice that XRP was not likely to be considered an investment contract under existing law, and then shared that analysis with the SEC and met with the SEC to discuss the legal status of XRP. As we understand it, not once during those discussions did the SEC indicate that XRP was an investment contract. Okay, look, so we knew, again, that the SEC did meet with an exchange talking about XRP, and after that meeting, the exchange listed XRP. That part's not new. What's new is that there's a law firm, we didn't know this, there's a law firm that told the exchange, yeah, so under current, existing law, XRP should not be considered a security. So how is that the case? How are you getting, like, is this just the worst law firm on the planet, or is it more likely the case that there is not clarity within the crypto world, at least not legal clarity? Well, of course it is. And this plays directly and strongly into Ripple's fair notice defense, which is this idea that, of course, for the better part of a decade now, Ripple's been openly, transparently conducting their business and selling XRP, and they didn't have sufficient notice from the SEC that what they were doing was illegal. And if that is what the court finds, then this case is over and they lose. But consider this. Here's an interesting take on this. Upon reading that, you know what I thought? I just thought to myself, the SEC, they told Coinbase that they couldn't offer their Lind product because they were told that their Lind product would be a securities violation. So for those of you not aware of what that is, it's been fairly big in the news within the last few weeks in particular. But Coinbase wanted to offer a program that they called Lind, L-E-N-D, in which they would offer their customers interest-bearing accounts. So you could basically loan your crypto out effectively to Coinbase, and then Coinbase would lend it out to whoever, and then you earn interest on it. Basically what banks do with your savings accounts. They take your money, lend it out, and then you earn like a tiny bit of interest on it. Basically, they'd be doing that with crypto, except for you'd earn a bigger percentage, right? So what Coinbase did is they shared that program with all the specifics of it with the SEC, and the SEC then came back almost immediately and said, hey, if you do this, we're going to sue you because you'd be selling securities. And they never even explained to Coinbase why, from their perspective, that this Lind program would actually be the offering of securities. They weren't transparent and didn't say that. But they did come back and provide feedback to Coinbase, right? Okay, that's an important point, because why wouldn't the SEC then, when they met with this exchange, who had legal advice from from a law firm that XRP is not a security, why wouldn't the SEC at that moment in time, back in 2018, why wouldn't they chime in there and say, oh yeah, well, if you do list this, just so you know, this is an investment contract and we're going to sue you? Because they did this, that's what they did with Coinbase. So why wouldn't they do that with Ripple and XRP here? Well, it's pretty obvious, isn't it? It's because the SEC hadn't decided how to regulate XRP. And if the SEC hasn't decided how to regulate XRP, then how the hell was Ripple supposed to know that what they were doing for the better part of a decade was illegal? That's the fair notice defense. And so if that's the case, the SEC loses. This is all astonishing stuff, isn't it? That's all that's why I've refrained from using the term bombshell for this video, but it's just like every time one of these damn things gets filed up from Ripple, it's just amazing revelation after amazing revelation. I love reading these things now. I've actually come to it. But anyway, next on to, I think I'm going to move on, right? Yeah, okay. On to page 3 now. Here we go. Defendants traded XRP on 34 platforms. The requests in this set are designed to elicit admissions that help establish that for most, if not all, of those platforms, there is no dispute that the trades conducted on them were outside the United States, and or that the SEC has identified no evidence demonstrating that trades on those exchanges were domestic. And so this is relevant for a rather obvious reason, which is that this is outside the jurisdiction of the SEC. The transactions that do not occur within the United States, the SEC has no control or power over from a legal perspective. And yet, they still claim that every single one of these transactions represents an investment contract. These are securities transactions, but they can't be if they occurred out of the United States. And we now know that the SEC, because they admitted on accident that they didn't even read the damn things. They're just making the claim. They're making these wild assertions because reasons. Why not? They're the SEC. They think they're God. They can do whatever the hell they want. That's the attitude that they have. And screw Ripple and screw the people that hold XRP. If it harms them, they don't care because they're a bunch of asshats. And then there's this. The sixth set. This set, to which the SEC devotes the bulk of its attention, seeks admissions concerning the content of the contracts by which Ripple sold or distributed XRP. These admissions are directly relevant to the SEC's claims that, under Howey, Ripple's sales and offers of XRP were investment contracts. Admissions to these requests would establish, for example, that the contracts did not include any promises by Ripple to increase the price of XRP, to develop the XRP ecosystem, to improve the XRP ledger, or to share in any of Ripple's profits. These facts would directly undermine the SEC's Howey arguments, and in particular, its arguments that XRP purchasers joined in a common enterprise in which they had a reasonable expectation of profits based solely on Ripple's efforts. And so here you go. The SEC has made the claim, that XRP satisfies all four prongs of the Howey test. Let's see if I can rattle them off the top of my head. I've been getting better at this, buddy. Investment of money with an expectation of profit, that's the second one. On the efforts of others, that's the third one. And then the fourth would be with a common enterprise. Woo, hey, go, man. I'm brushing my shoulder off. Can you hear that? Brushing my damn shoulder off. And so the SEC had made the claim that XRP satisfies all four prongs of the Howey test, yet they don't seem to know how to argue that their point is accurate. It just gets more and more ridiculous. I know. The SEC, everybody. Round of applause, sarcastically. And then there's this on page 4. The RFAs are neither difficult to answer nor burdensome. They seek obvious and indisputable admissions apparent from even a cursory review of each document that the contract does not include, for example, quote, any provision in which Ripple promised to engage in any efforts to increase the price of XRP, end quote. Or, quote, any provision that entitles the counterparty to share directly or indirectly in Ripple's profits or net income, end quote. We do not expect any of these admissions to be disputed, nor does the SEC suggest they will be. Right, and so look, these admissions, they don't want to answer them because the truth, if they answer truthfully, it would harm their case. That's the obvious answer to all this. Because there was never any sort of investment between any sort of XRP holder, URI, or anything else, any sort of promise of sharing of Ripple profits, this or that. Nothing of the sort. Nothing. There is no investment contract. And then on page 5, and I think this is the last part I wanted to highlight, because the 6th page is just the signatures, I believe. Yeah, that's it. So this is like the tail end of this document here. Ripple's attorneys write the following. Finally, the SEC asserts, without elaboration, that the RFAs are unduly burdensome because, quote, it is unclear how defendants would ever use the SEC's responses at trial or on summary judgment, end quote. This, again, misunderstands the purpose of RFAs, requests for admission. Admissions to these requests will narrow the issues so that the parties can avoid introducing 1,700 separate contracts at trial so that they can exclude from trial the hundreds or thousands of transactions that occurred outside the United States, and so that they can save the courts and jury's time by omitting other undisputed points relating primarily to the fair notice offense. Exactly. So the RFAs, they'd be doing exactly what they're supposed to do, but again, the SEC doesn't want to answer them because it just guts their case. It does. Because they look, if they want it to not gut their case, they'll have to blatantly lie, and then when the facts come out in the case, they're screwed anyway. So they're just trying to get out of saying what is reality. That's basically it. That's the assets. That's what the assets have been up to lately, folks. That's it. I'll go ahead and wrap up there, though. I am not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.